This is Paul Turner, the Immigration Barrister at Imperium Chambers. There's been much talk about the case that's come out recently, DK and RK Parliamentary Privilege, and the ruling by the court that the reports from such bodies cannot be relied on in judicial proceedings. Now, and there's been much on social media around this in respect of the ETS Toeic cases. However, the conclusion that the parliamentary reports themselves cannot be relied upon by the somewhat old and archaic law, in particular Article 9 of the Bill of Rights 1689, which, if looked at in any detail, is certainly an arguably religiously discriminatory piece of legislation, doesn't tell the entire picture. It's certainly not the end of the story. Because the most important part of it was that after much argument, the Upper Tribunal concluded, and this is very important given the ETS cases, that whilst the conclusions of the Appg report could not be relied upon, so one can't use the report itself, the evidence given by the experts to the Appg report, who had previously given evidence in other ETS cases, pretty much damning ETS, was allowed to be admitted and considered. Indeed, a transcript has been provided of the evidence that the various people I'm going to mention was provided. On reflection, this evidence carries much more weight in my view and is far more detailed and damning than the conclusions drawn in the actual report itself. The evidence of Professors Summers and French and Dr. Harrison do not help the Secretary of State. And the transcripts of their evidence is to be admitted and was admitted at the substantive hearing. In short, Professor Summers says that the ETS is unreliable and Dr. Harrison didn't really dissent from that. What is more interesting and potentially very damaging for the Secretary of State is that Professor French, from the Home Office rely upon for this, said that his conclusion that there would only be a 1% error rate was based upon the evidence being given to him being correct. And this is something that the Home Office rely on in almost all the appeals I've done. And now we know, through the findings of MA, that quite frankly there was no chain of custody, and therefore that Professor French was working on the assumption that the material that he was provided was reliable evidence. Now, we all know that to be laughable. Indeed, ETS were investigated for criminal complicity, and in the end paid the Home Office 1.6 million in an out-of-court settlement due to their abysmal handling of the entire situation. So in short, while the reports themselves were excluded, the evidence given to the Appg and the transcripts, which are far more detailed, is not, and was relied upon at the hearing over the 1st and 2nd of March 2021. So far, we don't have a decision on that, and the matter is ongoing. And so the case as to whether the Secretary of State has actually, whether the appellants actually have a case to answer and whether ETS can be relied upon, still remains to be determined by the Upper Tribunal. So this case that's come out, as it were, in the middle of it, does clearly say what you can't put in, but crucially, what is potentially overlooked in a lot of the coverage of this case is the fact that the tribunal did say that the evidence given by the reputable experts, which does damn ETS, could be considered by the tribunal. This is very important and should not be overlooked by any practitioner doing an ETS case. This is vital. If you have an ETS problem or a Toeic problem, please contact me and I'll do my best to help you. And in any event, I really wish you the very best of luck. I hope you've enjoyed this video. I hope it's clarified something which is quite important. And as I say, please subscribe to my channel. Once again, thank you for watching. This is Paul Turner, the Immigration Barrister at Imperium Chambers.